I can't tell you the number of times I've stood before a jury, selecting that jury, and the process is called voir dire. That's the process of impaneling the jury. And we talk about the issues of he said, she said cases, where one person is making an allegation against another, the other person saying, I didn't do it. That happens very often. And so it's amazing the number of times that clients come into our office and they say, well, how could this possibly be that I'm being indicted, that I've been charged with a crime when only one person's word, it's just, that's all that's there, one person saying I did something. Can you actually be prosecuted under that circumstance? And the answer is unequivocally yes. It's been unfortunate, but I've stood in so many courtrooms where the only evidence against my client was just the word of one person. And so the answer to that is yes. The answer to that is that just because that is the situation, a prosecutor is not necessarily going to throw that out. And so, you know, there are times where a client says, well, I'll just wait. The prosecutor has to throw this out. They have to realize that just because someone said something, that's not enough. If you do find yourself in that situation, you know, I submit to you that it is enough. And that case, just the he said, she said, one person saying something happened, has gone to the jury. The jury has had to decide that case. I've been there. I've seen it all too often. If the case is not prepared correctly, you do run the risk of a conviction based merely upon that evidence. So at our law firm, we prepare as though there are 100 people accusing you of that offense. Even in that situation where it is just one, we prepare as though it's caught on videotape, so that at the end of that case, we hope to secure a favorable verdict, and we hope that that accuser, that one person, forever remembers that they can't just make an allegation against someone and hope that that's going to fly.